Go. Test, test, test. Okay, audio is going. That's good. Um, let's see here. We were on chapters. Let's see, this is six. Child witnesses. Talked about that. This thing used to tell me where I left off, and it stopped doing that.
Where are we now anyways?
We're in chapter 5/6 because I know that we were talking about this. I thought we had gotten into judicial notice, but I couldn't remember. Impeachment we talked about. Objections we talked about. No, we didn't get that far. So we're in this one. Because I know I've talked about the different types of objections, but I didn't go into it. Okay. Direct examination, cross-examination. Then we'll go into judicial notice. That's this one, right? Yeah. So I tend to try to, depending on the class, in terms of how close I try to stay to the textbook, because some of them it makes more sense to stick pretty close to the textbook, some of it doesn't. And then if I know the stuff pretty well, I'm more likely to depart from the textbook because it'll make more sense by the time I'm done. This is one where I stay pretty close to the textbook because I don't normally get in this stuff very much. And so I have to stop and remember what things did I actually talk about, because I'll jump around as conversation goes. So we've talked a little about objections and the fact that they need to be made contemporaneously to issues, but I can't remember if we talked. I know we didn't talk about different types. I thought we were talking about judicial notice in a couple of different things. But we'll go into some details about that. And we'll talk about hearsay and some stuff like that. So we'll see how far we can go. We got objections. We have judicial notice, and we might get in hearsay. I don't know if we will. Admit. All right, let's see. Direct examination, cross examination. No, about that already. Okay, we'll start there. Boop, boop. All right. Chat participants. Let's see about moving this over a little bit. There it goes. So for today in evidence, what we'll be talking about. Going over objections, then we'll move into judicial notice, and depending on how fast we go, we might get into hearsay, we might not. I don't know. We got 4 minutes out. So what's going on? No, we've been paying much attention. What's been going on in the world? Yeah. I know that like the politics stuff's gonna be keying up for like what is it, the next 2 months kind of thing. And then we'll see what happens after that, because it might be something where it doesn't calm down afterwards. That's what it did last time. That's one of those things that's always really interesting to me. Because it's something that I think put my finger on a little bit what bothers me about it. Time frames and that kind of stuff, of course, where we're at being colleges and all that. Last time we had a civil social issue like this, 1960s kind of thing. It was college students who led the way. It was something I was actually listening to music. I forgot what it is that bothers me so much about it. Have you ever listened to the Beatles song Revolution? Yeah, there's a lot of songs from that era that have that kind of feeling when things are falling apart, a lot of chaos kind of stuff. If you listen to the words, it's actually pretty cool. But it's the ability to say no. As in, no, we're not going to fight. No, that kind of thing. It's flower power. 1960s, most powerful images I've ever seen from that era. Of course, there's the Burning Monk. If you guys have ever seen that one, that one's from was that China? That was a social statement about politics and kind of stuff. Guy set himself on fire. But the flower power one was really, really important because it was Miller's hair with guns pointed at you. No, we're not fighting. We're not moving. And it's like that element is one we kind of need back in society again today. It's the whole, I guess, reasonableness and violence kind of thing. But that is the world we live in. There's always that capacity for danger and violence and that kind of stuff. But let's see, 2 minutes. Let's see what else has been going. Revolution. There's a couple other songs that have that same kind of feel to it. Ooh, another one. This one's from the 80s. You guys ever heard the song 99 Red Balloons? That one's from the 80s. It's in German, if I remember it correctly. It was like 99 something or other. Basically what it was is that's also one of those ones that they're trying to get that feeling of the end of the world coming across it. Basically what's funny about it is that one has a little bit, the only reason I remember is that a little bit of the story. What it was that 99 red balloons were let go and it set off the radars and triggered the end of the world. It's the story of the song. The reason I remember it is because that almost happened, but it was geese. Yeah. Maybe it wasn't geese, it was a radar blip. That's what it was. There was one in Russia that was like that. Guy's last name was, I can't remember his first name. I think it was Alexandrov, but his last name was Petrov. With what he was received in terms of radio or radar was sufficient for him to press the button. He said no. Yeah. Otherwise, we don't need on. Like kind of a big one to keep in mind. Let's see, evidence. So objection, we'll talk about those. That one will go pretty quickly because we'll just talk about the general categories it has here. Then you'll have to realize, of course, that it's going to deal with, again, the specifics of the case you're dealing with. But you'll see those categories and see how they work. Then we'll move into judicial notice. And then if we get through that, we'll move into hearsay. So let's get ready to start cooking with gas. Objections. So far, what I've told you is that for the most part, they need to be made. Contemporaneously, meaning at the time that something's introduced into the record, you need to lodge in that objection just as quickly as you can. All right, so you have to think about the effects of what it is that's happening and what it does to the trial overall, or those specific facts at hand that they're dealing with directly in that moment. Let's leave that and come back through. So if you're going to make objections, you need to be present, you need to be paying attention to what's going on. So if you start thinking about the objections that you've seen probably depicted, or if you've ever watched a trial, they come in at different times, they come in different forms. Biggest thing is that you're going to make an objection. There's something about what's coming through that's going to have a harmful effect on your case. So the more that you can limit that effect, the better, right? Let's see. Categories that they give you. It's impeachment. We'll talk about that a little bit first, because that's one of those things that will come into objections too. So there's a few elements that are going on at any point in time. So we've got witnesses, we've got documentary or other forms of evidence being entered into the record, and someone's testifying to that fact. So since they're testifying, we should probably talk a little about it. Impeachment, we'll also talk about it probably a little bit more when we get to hearsay. So you all know what impeachment is, yes? What is it?
Like you kick them off their job.
Yeah, yeah. You're removing something out of something, like if you're dealing with like jobs. Yeah, the government stuff. Get that person out of office, right? Same thing here, only what it is you're dealing with witnesses, right? Whatever that person said, if they're so false in what they've said, get that out of there, right? And so here's how they do it. If you're going to impeach a witness, there's a few different ways to do it. You can attack credibility qualifications, whether it's prior record or some other thing like that. You can attack the testimony itself or the witness's credibility in terms of character kind of thing, right? Just like we were talking about the beginning of the semester. Facts are in your favor, argue the facts. If the laws are in your favor, argue the law. If neither, go for character. Let's see here. Goes over here now. Gonna turn this off for a second so I can see buttons. Here we go. All right, gotcha. Share. Let's see if I can grab that, move that over here. Kind of in my way. No, not there. Whatever. Okay, there we go. So same kinds of things. Objections. You know who lodges those. It's always the lawyers. You do so for the reasons already identified. And failure to object waives the grounds for appeal in most instances. Right? You missed your opportunity. That thing got entered into the record. Too late now. Right? Whenever you lodge an objection, it goes right to the trial judge. That's your ref. And so they'll make that determination, right? Whether it's relevant, material, competent, that kind of a thing. And so you have objections to the substance, the form, and the answer. Substance of the question, the form of the question, and the answer. So depending on what stage you're in, the form of the question can change some. I've mentioned a little bit about leading questions. Sort of like whenever you're direct versus cross-examination, right? If they're your witness, that kind of thing. Sometimes leading's a little bit more loud. If they're not, well, you might not be doing the same thing. Okay. Form of the question, relevancy. Basically, why are we asking this? Sometimes it can be straightforward, easily identifiable. Sometimes it's not. Some of the best ones aren't because you'll take a few side steps to come at it tangentially. That's one way that you can blindside people is you're moving abstractly through things and you hit a few different points that once brought together will identify something. Objections to the answer. Here it mentions unresponsive. The person wasn't responsive. You can do it like that, or it could be something about that answer itself you don't want in, or even like you can form the question, substitute question. The way it's presented can lead into interpretations itself. So you have to keep all those things in mind as you move forward. How is the question phrased? What is its general intent? What is it trying to do? What is the information it's trying to pull forward? And how does it fit? Are they being honest? Ooh. Objection to the answer. That's that. I think it's going to go back into, relevant material, competent. Sometimes we'll talk about probity. Probity is how probing it into a situation is into the matter. I didn't talk about that in this textbook. Relevant, competent. Okay. Just facts, testimony, or physical object must be shown. Addresses material fact. It's relevant. Able to affect the probable truth or falsity of that fact. Probity. Okay. If the fact is material, it affects the result. If it's relevant, makes a fact more or less probable. I don't know why they've got this slide so many chapters in. That slide should be pretty early on for as many times as they've mentioned those terms as early on as they mentioned it. Okay, here's what they talk about: redirect and recross examinations. Basically, that's to poke holes or rehabilitate testimony of witnesses. You've already seen this. Is there anything I need to tell you about this? Basically, these go on as many times as they have to, right? You can redirect, recross as many times as you want until you have no further questions. So, It's a hot seat for a witness. Additional witnesses may be used to rebut or assist. Yeah, the evidence also presented cross-examiner, open door, new matters. Yeah, that's the other thing is be careful what you ask. Because as you ask certain questions, you can allow the conversation to shift into different directions, right? Example. So I mentioned this guy a few times because I like some of his legal stuff. The defensive shooter guy, expert witness, has a tendency to charge a certain fee for his testimony at trial. Every now and again, he'll have a case where the facts of it are so egregious that now this one's pro bono, right? Doesn't always disclose that, and so at some point in time, a lawyer is going to ask, "Well, how much are you getting paid for this testimony?" Oh, now you just open up a door there because it's zero. Why is it zero? You don't want to ask that question because if you ask why it's zero, he's going to tell you exactly why you made that determination. That's going to change some people's opinions on stuff, right? You're telling me an expert who can charge X number of dollars is doing this for free. For what reason? Because it's so poorly run, or this is an abuse of justice or whatever. Or maybe this is justice itself. Yeah, jury's going to weigh pretty heavily on that. You have to be very careful. Yeah, recross is usually confined. That way you bound it in as much as you can, but it is very difficult to do that. Okay, role of trial judge, rules on motions, objections, objects, or both. Okay. May not comment on the weight of the evidence. Again, we want to keep too many people's biases out of here. I'm trying to think if there's anything else I want to say before moving on. I don't think so. Okay, it's going to reference rules of evidence. The trial judge can interrogate witnesses. Yes. Jurors are permitted to question witnesses indirectly through the trial judge. So if you've never seen that, if there's any questions that arise or anything like that, jury has the opportunity to ask those questions. Typically that comes up in like that deliberation process, that if there's any questions that are standing, they'll be able to submit those and get some more information on it. Even if that more information is to the effect of everything's already been presented, you need to make your decision. Almost all federal courts permit jurors to ask questions of witnesses by submitting questions to the judge. Yes. So if they'll bring them back up. Hypnotize people as witnesses. Pseudoscience. Right. When you start dealing with it, it's difficult as it is to factually establish things that really actually occur. Once you start getting into this area, like bets are off. You got to be able to really make your case. Right. Now, here you go. If you're suggestible, what are your intents? Can you be confused? What's the likelihood what you're getting is true versus artifact? Not easy. Charged with manslaughter under hypnosis. I've been able to remember what before hypnosis. Yeah. We are not now prepared to endorse without qualifications the use of hypnosis as an investigative tool. Right? So you talked about memories and how they can be affected and that kind of stuff. Well, this is a whole process that has a major effect on those, whether it's reclaiming accurate numbers or not. Results are always mixed. Like you can find stories with like, yeah, they were able to accurately recover a license plate from their memory. Or, hey, that was not the right person. So very difficult stuff. Okay, judge determines whether witness is qualified, competence of witness, and questions of law. Fact finds where we talked about the jury there. Good. Now we can move on to the good part. This is where we'll move into judicial notice. Oh, that's hearsay. Did I jump one? I did jump one. Now we go. All right. Judicial notice, witnesses, and shield laws. I remember talking with you a little about shield laws last time, I thought, because I talked a little bit about things that you can and cannot, testify on. Those types of relationships. That's where those things come in. Whether it's relationship shield, background shields, that kind of stuff. So objections. You have the form and substance of a question. You have the answer that you can make contemporaneously, and It's important. Let's see. Learning objectives. This is just a list of learning objectives. Okay. Judicial notice. Stop that right there. So what this does is not every fact needs to be established within the case, right? And if we have everything that can be disputed, these people are paid to spend time disputing things. We want to kind of keep that down to a minimum for anything we don't need to dispute, right? And so there's a lot of facets of life that, well, can be relatively proven. July 28th, 10 a.m. it was raining. By 2 p.m. There had been a thunderstorm that had rolled in, right? For this area. That's something you can specify. That's relatively incontrovertible. Relatively. You don't need to go through an argument for every single fact. So there's a few different ways that they do it. Stipulations I talked about, that's where both parties agree to something. To see that, they'll talk about that probably in expert witnesses because that's the most common place you'll see that brought up there. Others are judicial notices. So these are ones that come from the judge. Basically, the can be related to the laws themselves, how that works. It can be related to terminology. Here we'll talk a little about some of those generalized areas where they can start to touch some of those things. So, yeah, here's what it says. Parties, Charles, may also use joint stipulations. Yeah. So we don't have to prove everything because you have to prove everything here. So, first place you'll see judicial notice. Common terms, that kind of stuff. Let's see. Would be a good one. The one that's not commonly used so much anymore. Well, just think about your drugs in general, all the different terms associated with any drug given. Realize that those names change over time, but if you know, you know, right? I said, you know, what would be an example? Like Maui Wowie. It's like people knows that that's talking about marijuana. If I said, what is it? White Horse, something like that. Might be talking about heroin, right? Something like that. I gotta go back to the names. I don't remember them that well. Turning tricks, prostitution, right? Kind of thing. Okay. So whether it's, think about this one too. So, understood question. It's common term. Who's it common to? Realize you're dealing with different groups of people at trial. Sometimes you'll need that explanation, right? If I start dealing with, yeah, we'll go with the same thing. Some of those phrases become the average person. Some of those might only be phrases that, you know, maybe an officer who's working that type of issue, that type of vice. That's a language that's used around here. That's known by the police here. It's used in these frames. It's very common knowledge there that we can establish, right? So think about who you're dealing with here, because it'll be common. Might not be common to all the jurors. That's why they explain. Or it might be common to everyone, and they just have to note it for the record. Sex of the witness or defendant. That's one generally is the case. Of course, it's changing. It's happening. Well-known sections, well-known streets, buildings, that kind of stuff. Well-known habits too. So we'll deal with locations kind of thing. Locations and habits. They can overlap a little bit, right? So if I said, you know, this was over at the I-40 exit near Vian, mile marker such and such. It's like you can identify that pretty easily, right? Doesn't take much to establish that this is the location. It doesn't take much to establish, like, okay. Habits. So you're dealing with a strip mall. What kind of habits are going to be there? That kind of thing. So you can start getting into some of the types of behaviors that will be taking place in certain behind certain things, certain functions. You can establish them. So long as it's relatively well known. Okay, general knowledge. The health court should not take notice of facts or elements crime serve as the basis for increased prison sentences. Yes, you should not take just any matter of fact that affects the outcome of the trial, the severity, or anything like that. The judge is not the suspense trial. The judge isn't the one who's determined of that. That's going to be the jury. That's where they run into some issues related to judicial notice and jury instructions. Right? We had a little bit of a discussion on that when we were talking about the inferring the reasonable outcomes of one's actions. Right now, if that's coming from a judge telling a number of jurors how to make that determination, ooh, you start getting into some difficult territory. Right? This is that judge's influence, or is it working against their thing? And so you have to be very, very careful of that, because you can invalidate a trial. Okay. You may not take notice of a fact because it's well known to the trial judge themselves. That'd be another thing. You know this is a fact. Yes, I'm running the trial. So can we just take judicial note of that? No. Got to be more than just the judge knows it. Okay. Harvey, this is going to be Sapers Harvey, sales of illegal drugs. Yeah, here's where they talk about it. This is a clear example of that. Okay. So this is a drug distribution, drug selling. Basically what it is the way the statutes were written. If you're within a certain distance of certain types of location, this one's City Park, that's a aggravating circumstance. You're going to be looking at additional charges, different crimes. In this case, more severe penalties. Court made the determination that the person had, in fact, committed said crimes at said location. Prosecution failed to produce any evidence related to it, and the trial judge took notice of that fact, that where they were at. That was not a jury that made that distinction. Since it was the judge, nope, no candidate, right? Unconstitutional presumption, and it was mandatory, right? Because if you said that he's illegal, doing this illegal action, that is in fact right over here, even though we not talk about it in this case, you need to increase that sentence. That's the judge doing that. It's not the jury. The jury can find the person completely innocent for no reason whatsoever. So I have that whole nullification process in there. That thing's gone now because you have to find the guilt. No, you don't. That's him finding the guilty. Or her. I can't remember what the judge was. Okay. Now, prosecution attempt to justify investigative stop using evidence. This is a different case. Unsignal right turn, which was illegal if traffic was present. Failed to offer evidence of traffic. Took judicial notice of city intersections one of business. Found the investigative stop was unlawful. No reasonable belief that the law had been broken. Okay, so that's going to get off into probable cause. And we'll get into that a little bit, very tiny bit, because that's more of a procedural thing. Whenever you start dealing with probable cause, that's just more than likely that crime is afoot. You have to be able to establish that, like anything else, cumulative in nature. The more things you can say, the better. In this case, just because something would have been illegal doesn't mean it would have been illegal in that circumstance, because you don't have any evidence here. Even if it is one of the busiest streets, that's sort of like that's an aggregate thing, ecological fallacy. Yes, it's busy. Yes, there might be 100,000 people that go through that intersection at any given day, but at that specific point in time, for that 15 seconds, that person made that turn. Was there anybody around? Yes or no? We don't know. Okay, we don't. It's not hidden with that. that's how that should work. All right. Judicial notice of facts obtained from sources. So you can take different areas that you can take information from to use it to, I guess, substantiate judicial notice. There's always some backup documentation. Basically, anything that's reported, that's your treatises, dictionaries, data printed in newspaper. So basically, anything that's producing information that has some legitimacy and authority attached to it, right? They're doing that kind of thing. Trying to remember a case. This is one that's kind of going to run similar to that one. It was a racial discrimination case, because that's one where there's racial discriminatory practices taking place. The case itself, though, couldn't establish what was being discriminatory against them in particular. They could establish that those numbers were disparate in nature, potentially discriminatory. You can't make the case to show how it applies that person directly in that specific instance. There isn't any. May not be the case, but that's the way the court will. That kind of thing. Too fast. Right there. It's just like zoomed in or something weird. All right. Can be taken of a court ruling that scientific theory or technique is reliable. And guys, think about all the technological advancements we've had. Realize it started out with fingerprints and that kind of stuff. People weren't certain about that. DNA, whenever it came into the scene, it was nowhere near as accurate as what it is today. In fact, you can actually run into a whole bunch of issues related to, they might actually talk about it if I think about it, in the section where they talk about Fry and Daubert for expert witnesses, the standards there. Basically, what you start getting at is as technology develops, its accuracy massively improves. But if you go back to like the early 90s, or just 90s in general, they're nowhere near as accurate as what people are used to today. It's like, this is 99% likelihood that this is you. It's not what it was. It was like, there's an 80% chance that it might not be you. It's like, that's the kind of thing you start dealing with there. As you're dealing with expert witnesses giving their interpretations off of those numbers, they can massively overstate that to some degree. And so this is really important, but also that balance needs to be something that's communicated as well, because as those things come out, the techniques or theory might be sound or reliable, but their interpretations might not be. So you need to be aware of that. We'll talk about that in the expert witness section. State versus Broad, scientific action ascertained by reference, standard dictionary, or such general knowledge, yeah, whatever. That's just judicial notice in general, not specifically those standards. Here's where we get into self-incrimination. So this is where we start getting closer to the hearsay stuff too. So this one's interesting because this one's a little bit different than some of your other rights. So if I have if I have the keys to your home and I have a search warrant to search for it, what's the limit for the amount of stuff that I could get in terms of evidence? I have a key to someone's house. How much stuff do I have that I could use against that person? Just stop and think about that for a second.
Is that one of them, like when you start documents?
Yeah, so depending on how you do it, the specific nature of how you got access, how stuff that was after the fact thing, you're just probably going to be grabbing everything. But if it's something where you went through the proper processes, you got a search warrant, you did all that kind of stuff, yeah, you're going to have a very specific list. But you're only going to be able to take what's physically within that house, right? That's going to be bounded to some degree. The house is pretty big, right? Okay. That one's kind of scary to think about. Someone going through your house, going through your stuff. Does it make you a little bit nervous? I hope. Makes me nervous because I don't like people going through my stuff. Next one. It's in your phone. Okay. Think about it this way. Physical. Right? In your house, it's only going to be physical items for the most part. I mean, they'll have to put them together, pull out some meaning between them, but really you're doing physical stuff. This one. Anything that can be digitized. Right? What's the difference between that one? This one. Here's what's left. Here's where it's at. Unlimited. Okay. If I walk into your house, there's only so much stuff in your house. I take your phone, there's only so much stuff in that phone, assuming I've taken your phone, it's not in your possession, I'm just watching as you use it. This thing right here, you can talk as much as you want. There's no limit to how many words you can say. The only thing that limits your words and what you say, where you choose to. Right? This one's a little bit different than some of your other rights in that, yeah, the damage you can do here is also unlimited. This textbook, I was thumbing through a textbook about an hour before class. It's fine. Got a little bit of time in advanced class to think about what I want to talk about in here. I think in here it mentions in the hearsay chapter, it starts talking about a guy by the name of Walter Raleigh, Sir Walter Raleigh. You've probably heard that name before. That's the reason why hearsay is what it is. Basically, what you start dealing with is people in their words. There's not much else that's more evil, right? It's about as bad as money. This one's kind of interesting on the procedural side. This is the only one where they have to notify you, you have this right. Because if they don't, you don't have this right. That's why it's so important. It's it's like inverted a couple times over. Not only is it something that if you don't know, you have it. If you don't have, no, you have it. You don't have it. So it's really weird. That's this one. Right? When you start getting into it, we force you to talk. The only time that you have a choice not to. Right? When you start talking about it, put a little bit in here, so just a little bit, you should start thinking about it. Okay. When you think about people and the value of their words, how many of you look at the value of that person before you look at the value of their words? That's most everybody. That's a really frightening thing. Think about that when you read about Sir Walter Raleigh, because that'll probably be in this book. If not, we can find him on Wikipedia pretty easily. Basically, if you look back at the history of this system across time, it's not only last few hundred years is when we started to treat people as equal as best as we can. We're still not doing it well. You start looking at the weight of people's words, your position, whether you're a landholder, a title owner, or something like that. Yeah, that's how many, there's actual math there in some of the older generations, older cultures for how many people of what lower standing are needed to meet one person of this standing, right? You got one lord, you need it. What is it, a dozen serfs, something like that? I'd have to look it up. I don't remember the number, but it was there's a literally put numbers to it. Right? There's that stacking nature of those things. This one's really, really, really dangerous because when do you know if you're incriminating yourself? That tangential attack is what you'll be warding against. That's the thing you protect against. Your words are unlimited. They'll find something there, right? That's why they do all of the different interviews and different interrogations and different questioning. So that way, across all the times they've asked you all the same questions over and over again, how many different ways did you say it? And then take some of those different ways and put them against each other. Right? But you said you were hanging out with so-and-so on this date. Are you sure it wasn't this date? Well, wait. You said you were over here. It's kind of close to this thing over here. Sure you don't know anything about it? No, you don't. Well, you also said you didn't know anything about this over here. But obviously you're right here in the mix of this thing. And it's just going to spiral out from there. This is pretty dangerous. Visual producing evidence against him. Yes. Government's going to punish somebody. We need to do the work as the government. not make them do the work against themselves. Boom. So Fifth Amendment. Communicative or testimonial in nature, not documentary. Only as it relates to oneself. And we talked about some of those relationships. I go through them in this slide, I think, too, where they'll talk about husband, wife, clergy, medical professionals. There's one I didn't remember seeing. Wasn't thinking about it. Let's see if it's in there. All right. Yeah. Applies to materials, documents invoking which the person has sole possession, right? You have a written work in your possession. You don't have to give it over unless someone else has it. They've got a copy of it. They have to give it over. If it's damning to you, you don't have to give it over. Here is mentioned some examples of things that do not apply. Mentions blood, writing, speaking, that kind of stuff. You get into differentiating the difference between testimony and just regular evidence kind of stuff. So is it testimonial or is it documentary evidence? Those cases right there, the blood one's from like the 1960s. What was it? Vehicular accident. Person's in the hospital, was refusing to take the DUI test, that kind of thing, give over blood. So person's already in the hospital, turned to medical professionals. Hey, we blood alcohol in that. This is a time where they would do that. So they did. And yet, you're intoxicated. That person had that used against them. And since it wasn't in violation of any rights and they're already using medical procedures that were acceptable and necessary, that was acceptable to do. Handwriting or even voice, the whole you gotta make a recording of you saying something or anything like that. That's not testimony. That's an exemplar, meaning that's a sample for you to compare against others. It's not about what the actual content is or the fact that you said it. It's for testing against something else. And so that's how they're able to get those types of things. Okay, lineups. Here's what I talk about lineups, that kind of thing. Okay. Identification, putting a stop in mass at trial, permit witness testimony, with the mask robber. You can do that. Okay. Testimony witness if the defendant was compelled to put an item of clothing on the defendant. Yeah. So basically, you can make more certain things, that kind of stuff. Where immunity has been granted, person is compelled to testify. Okay, we need to talk about that for a second. Okay. So if it's for the purposes of an example, it's not testimony. If you're relating a story with that kind of a purpose, then it's testimony. The immunity aspect's kind of interesting because who grants immunity? Yeah, prosecution. It's in court side, but it's prosecution directly. And so basically, when you start looking at different immunity types, one is just like a blanket immunity, whatever you say is not going to be used against you. Sometimes it's a bit more specific where it's like, okay, you can testify about these things, and then maybe the derivative evidence, that kind of stuff, might still be able to be used against you. I mean, not just the fact that you said it's going to identify some things too. Speech runs a little bit differently than the Fourth Amendment stuff, exclusionary rule. People don't always realize that, in some textbooks kind of mistake them because they do run pretty parallel. If I had this or this and it points me in the direction of other evidence, if I don't have probable cause for these things, I can't use it. If I get this and it points me in the direction of other evidence, I can still go use that to get that evidence. As that's a little bit different. It's not going to be the same as the exclusionary rule. That's a different discussion. And so that's going to be a prosecutorial immunity. And so depending on what the nature of the case is, you can identify what a person's purpose is in granting said immunities. That's why in that Rittenhouse case I mentioned, it's like the defense kept identifying. Prosecution's got a witness that they're not offering any immunity to related to these specific gun charges. The person brought in a gun. They would grant them immunity. That person can speak freely, hear exactly what was going on related to this person. They didn't do that. They kept part of it hidden. Why? Well, nobody was a good guy there. That's why. So, yeah, you're trying to make good and bad people distinctions there. It's like it doesn't work like that all the time. Testimony is compelled. Okay. Yeah. And so if you're given immunity, you no longer have that threat of self-incrimination. So again, you're back to that subpoena. You have to speak. So you have to speak and speak honestly. Next up. Defendant is a corporation, unincorporated union organization. Incrimination of others, and it's not self. So there's where we're starting to talk about other things. Corporations, we talked about those last time, didn't we? Don't remember. Basically, whenever you get into corporations, when you start running into corporations, is realize that any corporation is itself its own entity. It's not an individual. So if you have, I think we were talking about conspiracies. If we were in here talking about conspiracies, that's how organizations work. It's like if it's for their own interest, that kind of thing, it's within the organization. It's not necessarily conspiracy. They're just trying to benefit the organization. If you're working between different organizations to conspire, that's a different thing. It's really back to territory. If you're two individuals outside of any type of formal thing like that, that's where you have a conspiracy again, potentially, depending on what you're dealing with. Incrimination is of others and not self-incrimination. Yeah, you don't have a Fifth Amendment there. Here you go. Protection. It says protecting children outweighs the Fifth Amendment. That's actually kind of a blanket exception to most everything. They call it exigency, is where you'll see it in certain places. Exigency is another term for emergency. Most common places you'll see it, because the only time that you really run into emergencies in our society most of the time is within financial stuff. So you see financial exigency. When you get into court cases, you'll see it in terms of an exception to maybe like the exclusionary rule or some of these others, because there's that sense of a real emergency that needs to be addressed in a very compressed time frame. So the procedures change a little bit. What we're allowed to do expands. Okay. Military. Yeah. Here you go. Where there's a waiver. Waivers need to be both voluntary and intelligent. It's not personal. What that means is you did it on your own and you know what you're doing. It'll be the same thing for any other waivers. Is whether you see voluntary intelligence or knowing and willing, you're talking the same thing. You need to do it of your own volition, not be influenced by others, and to know what you're doing. Yep, already talked about that one. Down book fifth. Yep, this one. They weren't actually in his possession. So that's where you start talking about constructive versus actual possession. Again, we talked a little bit about that in the previous classes, I think. If not, actual possession is tangible physically in my possession most of the time. Constructive possession would be like if I handed this bottle over to one of you. It's still mine. It's in your possession, though. We're subpoenaing people for it, though. You can't claim self-incrimination for this. It's in your hand. It's like, I could claim it, but it's not in my hand. Okay. So compelled testimony and self-incriminating or in any criminal case. There you go. Worse does apply. Even if you're innocent, it still applies. Refusing to answer specific questions. So usually they'll either plead the fifth or I can't remember. Those are your two options there. Notice it said on the tax return, because that's very specific, right? It would be related to very specific actions. Question by probation officer. Okay. They're mandatory options, then that's something different. Don't hold on. Defendant remains silent under questioning. Okay. Silence, we talked about standing mute. Silence isn't an invocation of anything, and depending on the circumstances, you can either note the fact, in this case, you might not be able to note the fact they stand mute, entered in not guilty. Attorney-client privilege we already talked about. Don't need to go too much detail into that one. Look, it even survives the death of a client. Yeah. Okay. Here's where you start running into exceptions for all of the special relationships. Basically, are you going after something criminal? It says crime fraud exception. That's going to be for basically all of the relationships it identifies. If the purpose of your relationship is in the pursuit of criminal activity, that relationship is void and null. You're only engaging in that relationship for the cover that it provides. And so we get rid of that. And so that's how that works, right? So you have that ethical obligation to produce evidence, but yeah. Spouse cannot be forced to testify against others, but again, that privilege extends to the one who has words to say. So they're the ones who get to invoke that privilege. Okay. Valid as long as they're not permanently separated. Let's see, cannot be spread onto others. So you say something private to your spouse in front of someone else, doesn't matter, it's no longer private. That's actually a court case where it was a husband and wife in an interrogation room, and they were talking in front of an officer. There was an officer in the room. What happened there was it was kind of a nasty thing where police officers brought in the wife and asked the husband why he did it. Remember correctly, I think it was he shot his own son kind of thing. And the breakdown, yeah, officers right there to see everything break down. I now have, okay, there you go. Supreme Court held spouse privilege does not apply to permit one spouse to invoke privilege against the other. Yeah, so that's where husband's trying to say wife can't talk, or wife's trying to say husband can't talk. They don't get to do that. That's nice. Okay, partner in crime exception. That's what they call it for the husband and wife. Same kind of thing. Both spouses involved in growing marijuana or trafficking cocaine. Husband ran off with somebody, angry wife provided that information. Yeah, that's fine. Testify in court. Some states limit exception, personal violence committed against the victim's spouse. Okay, at least one state. Exception of violence applied to persons outside of the immediate family of the accused. So, in some instances, you can only talk about that. Some places, not the case. Patient privilege. Physician patient privilege, we've already talked about. Diagnosis, you already know that. No psychotherapist patient privilege existed in common law, but privileges not available to patients charged with sexual abuse. Conditions, limitations, privilege, similar to physician patient, not in those circumstances. Okay. Don't care about that. Duty to protect. Okay, so this is where you start getting into patient stuff. So life is dangerous. Sometimes you're dealing with dangerous people, dangerous things. As you're dealing with that, the interaction between influence, opportunity, and responsibility. That's what you start doing here. If you're a doctor, you become aware that someone's got a mental defect that may have the potential for violence. What's the threshold for the likelihood of violence before you notify somebody? Is it just that person could be violent? They may be violent, they will be violent. What's the likelihood there? Because realize we set those at different things at different times for different people. That's not good. That's one of those things that gets really, really dangerous. That's why why so many things that would be protected don't get instituted, because the dangers associated with such. What would be a good example? Red flag laws, right? You have red flag laws that can strip people of their constitutional rights so long as that they're a danger. What establishes that they're a danger? Is it the fact they've engaged in certain behaviors, or is it the fact that they got a prescription for a depression medication, right? Because sometimes in some places that could be enough for someone to make that argument. It has been. That's how that goes. Is that the same thing as potential violence? Maybe yes, maybe not. But then realize that there's always someone who wants more. Right? There's those who want to control you to the point in time which they'll make decisions about your personal health for you. Right? We've already been there. That principle applies to this whole system. And that's why the system is as complex as it is, because of that danger. Okay. Tearsoff poses a serious threat to a third person, must exercise reasonable efforts to protect that person. See how they did it? With that reasonable standard. Not even the situation where the average person reacting to this, given these types of circumstances, these details, with that kind of education, right? California. Department's Evidence Code. Exceptions to this privilege. Communications by a dangerous patient are not privileged. So now you got a labeling of dangerous. Right? It's not patient if the label is dangerous. They have no exception to that. or they have no patient privilege there because they've been labeled as potentially dangerous. To what degree? That's going to be an individual level. I'm sure you're going to see some abuses if you look real close. Okay. Sexual assault counselors, privilege concerning other counselors. Yeah, you need to protect those receiving counseling. Absolute privilege, not only testimony, protection of documents, histories of persons. There you go. That's where you get victim advocate statutes. We talked about the clergy privileges because, well, that role. Clergy person don't have to engage in full-time profession, so they don't have to be full-time professionals. Legal protection, yeah. News reporters privileges. So these are other places where we protect people. Your sources, right? You've got sensitive information. You need to be able to verify that it's coming in. However, okay, most have these shield laws, except when life is at risk or situation concerns an emergency. On the other end of the spectrum, what was the problem we had with Walter Rowley? Unable to face accusers, put to death for it. Right? So that's the other side of the spectrum, right? To some degree, we need to protect these people for the information that they provide. The other end of the side is if people are using that information, what are they doing with it? Sometimes it's not good. Okay. Exceptions, like many states, privilege qualified, meaning they can refuse to disclose sources. Must make other information available through reporting activities. Yeah. Okay. Can be claimed by most professionals, so on and so forth. First Amendment does not create a privilege for a reporter to refuse to identify them. So that is not, well, it's one that we have in practice. That is not the way it's historically been. Right? Also, it wouldn't apply to grand jury proceedings. So when we're talking about information, start thinking here about leaking. So, questions to ask there. News people, other media representatives, great, 10. They're very helpful. Let's see, Edward Snowden, surveillance. It was 2013 here, as long before that. 2010, Chelsea Manning, WikiLeaks. Right? So between this mess that we've been talking about related to people's relationships, the purpose, the information associated with the good, the evil that can be done there, you also have everything else that's going on outside of that, like this. Right? So between your news people, between those who are involved, you have other things that can be taking place. And very real reasons you might want to have that information go public. Realize that those are crimes. Right? And so those people will treat it as such. Parent-child privileges. One federal court district and one state have recognized it. Right? Otherwise, you're looking at parents patriae. You've ever heard that phrase before? Okay, you should be familiar with it. Basically, what it means is children belong to the state to some degree. That's the principle for that. That's why we have the principles that we do for taking care of children. Here. Talks a little about that. Two parents subpoenaed related to statements about their children about raping a young girl. Children had done something very, very evil. Two parents get to be, no, that's my child, I can't say. Whoa. That's a hard one. I'll leave you guys with that one, though. Think about it for next time. Have a good answer for that one. We'll come back to that one next time. Should a parent have to divulge the criminal actions of their children, or should they be allowed to be protection? That's a hard one. Pick up that next time, then we'll move on into hearsay a bit more. Have a good day. And we'll stop sharing. That's slide 40 on chapter 6. Have a good day, everybody.